Positive changes for 457 and 482 visa holders. Welcome back to our channel. Today we are going to discuss the temporary skilled shortage subclass visa. In 2018, the temporary skilled shortage subclass 482 visa was created, replaced with subclass 457 visa, resulting in the short-term occupation list established. The STSOL permitted businesses to sponsor applicants for up to 4 years. Still, applicants were not qualified for permanent residence through the Employer-Nominated Scheme, ENS, subclass 180. The Australian Government, November 2021, officially announced its purpose to enhance access to permanent residences for existing temporary skill shortage, subclass 482, visa holders, in the short-term stream, and legacy temporary work skilled subclass 457, visa holders who no longer fulfill the age requirement. The government, on the 18th of March 2022, introduced new legislative conditions, creating permanent residence pathways for past applicants who were excluded. 482 visa holders nominated in the STSOL. In March 2018, changes impacted many of the candidates and their employers sponsored on a 482 visa in a short-term stream profession. Those who had spent at least 4 years living, working and contributing to the Australian economy now had restricted opportunities to shift to permanent residence. After a short period on their temporary work visa, the Australian economy has restricted options to transition to permanent residence on working and contributing after a short period on their temporary work visa. Current changes to 482 visa legislation. From the 1st of July 2022, employers might be able to nominate sponsored 482 TTS workers in the short-term profession for the ENS-TRT stream if the candidate was in Australia for about 12 months, from the 1st of February to the 14th of December 2021. Please note that the legislative instruments do not define the candidates need to have a 482 visa during the period. So, the candidate must hold a visa. When applying for an application, it works for an individual actively and lawfully running a business in Australia, and also been employed in the nominated position with the same employer for around 3 years less. Suppose the COVID-19 unpaid leave or COVID-19 reduced work period is specified. Periods of unpaid leave will surely not be countable to the 3-year requirement. Candidates are still required to be under 45 years of age when applying for a visa, until and unless they claim an age immunity. Still, those candidates who held a 457 visa on or after the 18th of April 2017 and were in Australia for around 12 months, from the 1st of February 2020 and the 14th of December 2021, will be free from the age restriction. Candidates not living in Australia for specific months from the 1st of February 2020 to the 14th of December 2021 will not be qualified. 457 visa holders, pre the 18th of April 2017. The Australian government enforced transitional arrangements after cancelling the 457 visas in 2018. These aim to confirm that 457 visa holders could still grant permanent residency. The transitional arrangements were active for grandfathered 457 visa holders from the 18th of March 2018 to March 2022. Grandfathered 457 visa holders are the ones who meet the following. Applicants held a 457 visa before the 18th of April 2017 or applied for a 457 visa before the mentioned date. With the visa subsequently being granted, redirect to the previous information. If I am a 457 visa holder, do I qualify for permanent residency? Changes from the 18th of April 2017 to 457 visa legislation. The government introduced legislation on the 18th of March 2022 to hold these transitional arrangements in place. Suppose anyone wants to apply for permanent residency or permanent residence visa. The applicant must be a 457 visa holder or held or processed for 457 visas before the 18th of April 2017, subsequently granted access, and worked in the nominated position with the same employer for around 2 years unless the visa authority determines the COVID-19 unpaid leave period or COVID-19 reduced work period of unpaid leave will not be counted to the 2 years of requirement. It is still undefined whether a candidate could be under 50 years of age at the time of application. 457 visa holders post, the 18th of April 2017. The current law also includes the ones who fall under the following. A candidate who applied for and was granted a subclass 457 visa after the 18th of April 2017, stayed in Australia for at least 12 months, from the 1st of February to the 14th of December 2021. And when applying, the candidate must be employed by any individual who is actively and lawfully running a business in Australia. This includes subclass 457 visa holders with the following. Candidates who were unable to access transitional arrangements implemented to 457 visa holders pre the 18th of April 2017. Applicant must have a profession that is not on the medium-term stream. It is a welcome change, an enhancement to the TSS 482 scheme. It has beneficial impacts on many temporary visa holders and Australian employers. The changes demonstrate that the Australian government is heeding the Australian society's concerns and recognises the significant contribution of 457 visa holders, specifically in the short-term occupations, to the economy at the time of the COVID-19 pandemic. We have reached the end of today's video update. Like, share and subscribe to our channel for more latest updates. Thanks for watching.